Final state witness in the trial within a trial in the Senzo Meyiwa murder trial, that's Dr Thabang Hlokwa, says there was no signs of assault in accused number 2, that's Bongani Ntanzi, who the state has described as a gun supplier and hitman. This despite Ntanzi claiming he was assaulted by police in 2020. The testimony is part of the evidence to determine the admissibility of confession statements signed by Bongani Ntanzi as well as Nthabiseng. Joining us to tell us the possible implication of this testimony is legal expert Nthabiseng Dubazana. Nthabiseng, a pleasure to have you on the program this afternoon. So, the recent testimony from Dr Thabang Hlokwa suggests that there were no signs of trauma or even assault on Bongani Ntanzi during his dental examination. How might this impact the defense's claim that Ntanzi was severely assaulted and also forced to sign a confession statement?
Well, if there were no physical attributes towards or showing that there was an assault that happened, there could be other forms of assault. If you recall, the advocate Mgomezulu for accused number 1 and 2 had stated that the assault that happened against accused number 1 and 2 was tubing. So tubing usually does not entail a physical situation where you're beat with fists or something with that affiliation. But what would happen is that you are tied up and then you are dunked in water and then to make as if you are drowning. And that doesn't necessarily leave any sort of mark on the body. Now, having said that, what usually happens is that if there are no physical signs that there was an abuse that happened or an assault that happened, when we are filling in what we call a J88 form or when you go see a doctor, it is always imperative for you to inform that doctor that, listen, I suffered X, Y, and Z at the hands of the people that brought me here. And as a result, I would like for you to do an extensive test, because if they don't know what to look for, they will not look for it. So, having said all of that, I think now the ball is within the presiding officer's court to decide whether or not there was sufficient evidence both from the defense side and the state side, and then decide which one is better. But based on what we are seeing with the evidence that has gone by so far, besides the actual assault that happened against accused number 1 and 2, we are seeing the way in which this confession was conducted in terms of Section 35 rules. And we see that it is lacking in that situation, which may sway the mind of the presiding officer.
Another interesting aspect was the absence of a gold tooth on Bongani Ntanzi. It does contradict earlier claims which were made by the prosecution regarding some of the suspects in that house on that fateful night. How significant is this revelation also in the context of the trial? And how might it influence the perception of these alleged events?
When it comes to the main trial, it may not have any bearing whatsoever, because that would lead probably to the merits of the matter. And what we are currently dealing with is a trial within a trial, wherein we are trying to determine or ascertain the admissibility of the confession that was signed by the accused. So, with the fact that accused number 2 did not have a gold tooth per the way he was described, or one of the perpetrators were described to have been in the house, may lead to an identification issue. If you recall, in the beginning of this new trial, not the first trial under a different presiding officer, there was the issue of identity of the accused persons, that the people who identified the accused person could not possibly have seen the people the way in which that they did. Some were running, some were seeing them at a far stage, and those who were within the house don't seem to have a clear recollection, especially because we're dealing with alcohol consumption, we're dealing with a chaotic situation. But that will, if they leave that evidence in the main trial, then perhaps it may sway in the direction that perhaps the accused persons may be found not guilty. But apart from that, for now, in the confines of trial within a trial, it may not have any bearing per se, because here we're trying to see whether or not the accused person gave the evidence, or rather gave the confession without any undue influence that was given or that was placed upon him.
Which leads me to my next point. I mean, as a legal expert, can you explain the importance of this ongoing trial within a trial that really focuses on the admissibility of the confession statements? And how might the outcome of this affect the overall trial?
So the state, in their docket, they are using these confessions to say that even though you're here defending yourself, saying that you did not commit this crime, we have a confession from you that says otherwise. And now the defense attorneys are saying, yes, you may have this confession, but this confession does not follow the rules, the way in which it was conducted. So we look at section 217, 218, 219 of the Criminal Procedure Act, right? So now, at this stage, the court has to decide whether it can take these confessions and make them evidence of the court. So for now, they haven't been handed in so they can form part of the evidence that has already been handed into the court. It is only within this trial, within a trial, where we're trying to consider whether or not that confession is admissible or not. So part of the rules are that the confession must be freely and voluntarily done. You must be in your sound and sober senses, and then it must be reduced to writing in front of a magistrate if it was given to a peace officer. So from what we are gathering, is that these confessions were given to various people at an arresting stage, somewhere in a dumping site, and then here with the IO who said something else. And then they went to the Boksburg, I think, Magistrates Court, wherein this confession was reduced to writing. But all these things, the way in which they happened, do not seem to follow the rules. If you remember, Advocate Msholol, I believe it was, the way in which she was asking whether or not before the accused persons gave this confession, the rights were read to them. It was important and very significant why she asked that question. And unfortunately, the IO didn't see this, or rather understand it. In the pre-constitution, the interim constitution, in a 1994 case, I think it was Justice Chuckelson at the time, he made a ruling in the Constitutional Court and said, the rules of Section 35 in terms of arrested persons, their right to remain silent, should also apply to suspected persons. So the fact that you, as the arresting officers or as the SAPS, only deal with this and write it down at the police station violates the rights of the suspect, because they give you information at the scene of the crime or at the time that you arrested them, whereas you haven't given them their rights. So any information that you give them as the accused person before your rights are read to you, all that information is inadmissible in any court because it was attained unconstitutionally.
Let's look back at the testimony of Dr. Hlokwa. He did say that he examined one of the accused from the waist up, and the defense has questioned whether he went beyond the scope of his examination. How might the court then interpret the extent to which medical professionals can also examine a patient, especially in the context of potential abuse claims?
Well, unfortunately, if the accused person did not say to the doctor, listen, I was assaulted, I went through this, that, and the other, the doctor can only check at the tip of the iceberg. They won't go deep within the physical checkup. So it depends on what was divulged to him as a doctor, and then he worked within the confines of that. Because now, if we go over and beyond our scope of duties as well, that might be a violation of this person's privacy, person's right, because they did not give you permission or consent to examine certain parts of their body. So I think that one is a little tricky in terms of how we would hold any doctor accountable for not doing a thorough test in terms of what we as in the legal profession would deem it necessary. The doctors, unfortunately, I think at least, are bound by what their clients or their patients tell them is wrong, only when they have to do a severe or an in-depth examination because it's a health risk, then they are bound to do so by their practice. But otherwise, if a patient looks like they are okay and you've examined what you were asked to examine, then you are deemed to have, at least I think, you would be deemed to have conducted your duties.
So Nthabiseng, with the varying accounts presented in the trial, how crucial is it for the court to really establish the credibility of witness testimonies, especially when they play a key role in really shaping the narrative of some of the events leading to Senzo Meyiwa's death?
Credibility is very, very important. So if you flake, for lack of a better term, during cross-examination, and then your story starts to dwindle a little bit, it now throws a shadow on whether you are a credible witness or not. Because if your story is indeed the truth, it will stand the test of time. No matter what it is that a defense attorney throws at you, your story will remain. So here's the thing about defense attorneys. We'll ask you the same question 10,000 times, but in varying ways. And if you still stick to your story, we will move on. And then because we see, okay, you are sure about this aspect. But if we ask you once and your story changes already, we will hammer at that because we're trying to show the issue of credibility. So in this instance, there's so many stories that are so contradicting to one another. It makes one wonder whether or not the witnesses that are before the court actually saw what they deemed to have seen on the day in question. And also the thing that adds to that is that one or some of the witnesses are accused persons in another docket on the same matter. So it makes one wonder, are these witnesses to be taken as witnesses or as accused persons? How are they going to deal with it? And seeing as there's a pending docket at the end of this particular trial, the DPP still yet to make a decision whether or not they're going to continue with the accused persons in the second docket. There's too many things going on, in my humble opinion, in this matter, and I don't know how the presiding officer is going to deal with, deciphering the information that is there. And then another downside that I've seen so far in the trial is that so much information gets divulged during the trial. So there was not enough disclosure that was done at the beginning before the trial started, I beg your pardon. So a lot of information keeps getting given as the trial goes on, and then the matter has to stand down so the defense attorney can acquaint themselves with the information, go get instructions, prepare their clients, and then continue with the trial. That for me doesn't make any sense. It should have been given before the trial started. We can't be giving information as the trial goes on.
Thank you so much for your time. That's a legal expert Nthabiseng Dubazana helping us unpack some of the events at the Senzo Meyiwa murder trial this week.